Hey guys, thank you for coming back. So today we will be going over chapter 5, and that is labor and employment laws and regulations. First thing you want to look at here is your table of contents, and what I have highlighted so far is Labor Management Relations Act. That's something they will ask you in the exam. You also want to highlight Fair Labor Standards Act, FLSA. If you can't find it in the index, sometimes it'll be here, and that's why I highlighted these. You have exemptions, overtime pay requirements, and on the next page, we have record keeping, child labor regulations, number 3. We have garnishment. That's one they will definitely ask you about, so you can't find that anywhere else in the book but here. Garnishment, and it's related to labor laws. Next page is unemployment benefits, penalties, sanctions, special issues related to construction industry, penalties, sanctions, special issues relating to the construction industry, Immigration Reform and Control Act of 1986. You have record keeping here. Next page, we have the Fair Labor Standards Act, Florida Child Labor Law. That's one you really want to highlight as well. Florida Reemployment and System Program Law, Employer Guide to Reemployment Tax, and Employer Guide to Reemployment Assistance Benefits. First page, we want to highlight 512 under the Age Discrimination in Employment Act, ADEA. Treating employees 40 years and older. The Americans with Disabilities Act of 1990, ADA, by employers having 15 or more employees. Page 513, unfair labor practices. The LMRA prohibits interference, coercion, I don't know how to pronounce that, and restraint by employers, or coercion and restraint by unions when employees exercise their LMRA rights. Duty to bargain. Employers and unions have mutual obligations to bargain in good faith over wages, hours, and other terms and conditions of employment. Neither party is required to make particular proposals or concessions. Page 514, we have administration enforcement, the NLRB, unfair labor practice. An unfair labor practice charge, ULP, within 6 months of the alleged violation. So make sure you circle or underline these numbers. Representation elections. An employer may legally bargain with any union representing a majority of its employees. In the construction industry, an employer can sign a bargaining agreement with a union without employee majority support for the union. Florida right to work laws. Under coverage, we have exceptions to coverage include employees who work in federal enclaves, such as military bases, and employees working for airlines or railroads. Requirements, prohibitions. Florida is a right-to-work state. Specifically, the Florida Constitution, in conjunction with the Florida statute, prohibits collective bargaining agreements that require union membership as a condition of employment. Among others, Florida's right-to-work laws prohibit the following 3 types of agreements. Union shop agreements. Page 515, agency shop agreement, maintenance of membership agreement. Fair Labor Standards Act, FLSA, wage and hour law. General requirements. The FLSA is federal statute which prescribes minimum wages of $7.25 per hour for non-overtime work, overtime compensation at time and 1/2 the employee's regular rate of pay for hours worked in excess of 40 in any one work week. Equal pay for equal work between the sexes. Child labor standards and certain record-keeping requirements. Coverage general. All employees in business other than retail or service without two or more employees engaged in commerce or in the production of goods for commerce or otherwise handling or working with goods that have moved in commerce and which have an annual gross volume of sales or business not less than 500,000 are covered. Exemptions. The FLSA exempts so-called administrative, executive, professional, and certain outside sale employees to certain computer-related employees, among others, from its provisions and authorities authorizes the U.S. Department of Labor to enact regulations defining these categories which have force of law. Tests for exemptions. 541.400 General Rule of Computer Employees for computer employees. Key word here is FLSA. Make sure you remember that. You might want to tab it as well. Page 517, we have general rule for outside sales employees. 518, we have general rule for professional employees, general rule for administrative employees, and general rule for executive employees. I also put a tab there, executive employees. Each work week stands alone. A single work week as its standard and does not permit the average of hours over 2 or more weeks. Determining the work week. An employee's work week is a fixed and regularly recurring period of 168 hours, 7 consecutive 24-hour periods. Regular rate of pay. The regular rate of pay may be more than the federal statutory minimum 7.25, but it cannot be less. So they will ask you a question about regular rate of pay as well, and you want to highlight the footnote. In Florida, as of January 1st, 2021, the rate is $8.65 per hour and will increase to $10 per hour on September 30, 2021. The rate will increase every September 30 for the next 5 years until it reaches $15 per hour. Page 521, regular rate is a rate per hour. The regular hour rate of pay an employee is determined by dividing the total remuneration for employment except statutory exclusions in any work week by the total number of hours actually worked in the work week. Hourly rate employees, hourly rate and bonuses, different types of questions they will ask you. Hourly rate and bonuses, they break down the solution here for you. Day rates and job rates. Page 522, we have employees paid on a salary. We have piece worker. And page 526, we have discretionary bonuses. A bonus not need to be included in the regular rate if the employer retains discretion both that a bonus will be paid and 2, that the amount is not determined until the end or near the end of the bonus period. Page 527, we have pay for foregoing holidays and vacations. In some instances, employees are entitled to holiday or vacation pay but forego the holiday or vacation and work on the day or period. If they receive their customary rate or higher for work on the holiday or vacation day, the additional sum given as holiday or vacation pay is excluded from the regular rate of pay. Page 528, we have on-call pay. If employees who are on call are not confined to their homes or any particular place, but are only required to leave word where they may be reached, the hours spent on call are not regarded as working time. 529. Overtime pay may not be waived. Overtime must be paid 40 hours a week may not be waived by agreement between the employer and employees. Page 530, record keeping. This is very important as well, guys. They will ask you a lot of questions about record keeping. And here's one of them. Employers are required by regulation to keep so-called hard records, such as payroll, employment, contractors or agreements, and sales and purchase records for 3 years. All other records, required records, so-called soft records, must be for 2 years. Among other records, these would include time cards or time sheets. So they might ask you what includes hard records or what includes soft records, and for how many years for both. Administrative enforcement. We have wage. A 2-year statute of limitation applies unless a willful violation is found, in which case the statute of limitation is 3 years. Penalty sanctions. Damages include back pay, attorney fees, and costs. There are double damages for a willful violation. Criminal violation resulting in potential fines and or imprisonment are also provided by FLSA. Down below under type of work. Generally, children age 15 and under may not be employed in a number of occupations, including construction. So they will ask you a question about child laws. Children aged 16 and 17 may work in construction-related operations, but may not be involved in certain particularly hazardous occupations at construction site. Those occupations include motor vehicle driver, operation of power-driven woodworking equipment, operation of power-driven hoisting apparatus, operation of circular saws, bandsaws, and guillotine saws, shears, wrecking or demolition operations, and excavation operations. So they will ask you a question about this as well, and make sure you go through each one of them. Child labor laws number 3. Under Florida Statute Section 450.0612, no minor under 18 years of age is permitted to work in any of the following occupations: on any scaffolding, roof, superstructure, residential or non-residential building construction, or ladder above 6 feet. Hours. Under FLSA, minors who are 14 and 15 may work outside school hours in various non-manufacturing, non-mining, non-hazardous jobs under following conditions. Under that is page 532. Minors who are 16 or 17 may work unlimited hours in any non-hazardous occupation. These restrictions do not apply to family-owned businesses, other than manufacturing and hazardous jobs. For minors age 14 and 15, the allowable work hours are, for minors are, right there. For minors age 16 and 17, we have the allowable work hours are 30 hours a week when school is in session, 8 hours a day between 6:30 a.m. and 11 p.m. Make sure you highlight these numbers, guys. They will ask you a question about this as well for sure. I know I had it in my exam. So, enforcement penalties. Employers are subject to a civil money penalty up to $11,000. Make sure to highlight the numbers again. Section 450.141, Florida statutes, makes it a secondary misdemeanor to violate child labor laws. Page 533, Davis-Bacon related acts. Penalties, sanctions. Debarment from government contracts for up to 3 years may also be imposed. Page 534, covers all employers that employ 15 or more employees in each 20 or more calendar weeks in the current or preceding year. Labor unions and employment agencies. Enforcement. The Equal Opportunity Employment Commission, EEOC. That's one you really want to tab, because I don't think you can find that in the index. We also have, because Florida has its own anti-discrimination statute, charge must be filed 300 days of an event triggering prohibited discrimination. They will ask you a question about this, guys, about an event triggering prohibited discrimination and how many days you have to file, and that's within 300 days. So make sure you try to remember that as well. Page 535. A charge must be filed with EEOC within 180 days from the date of the alleged violation or in order to protect the charging party's rights. Down below, these caps apply only to individuals. Attorney fees may be awarded to the prevailing party. So you have number of employees. 15 to 100 will be $50,000. Here is maximum compensatory and punitive damages per plaintiff. Down below we have the coverage of FCRA. The FCRA, 15 or more employees for each working day in each of 20 or more calendar weeks in the current preceding calendar year. So this is an act. I'm pretty sure you can go under, in the index, you could go under acts and you will find FCRA. Let's look at it now. Acts, FCRA. Acts, FCRA. That says Florida Civil Rights Act. I don't see it. Florida Civil Rights 535. So that's it right there. Page 536, we have AIDS. The Florida AIDS Statute 760.50, Florida statute prohibits employment discrimination based on the results of HIV-related test or refusal to take such a test, unless the absence of HIV is bona fide occupational qualification BFOQ. That's the only exception. The statute also provides that persons with AIDS, ARC, or HIV have the same protection as other handicapped persons. All employees are covered by this statute. Alcoholism and drug abuse. Alcoholism is also protected handicap. The Florida Commission of Human Relations has yet to rule that during drug abuse is a handicap, in part because the possession of drug is unlawful. Enforcement. Administratively, the Act now requires that complaints be filed with the FCHR within 365 days of alleged violation. Back pay liability is limited to 2 years prior to filing of complaint. So remember that, guys, back pay 2 years. Page 537, Age Discrimination and Employment Act of 1967, ADEA. This is another act. Requirements, prohibitions. The ADEA prohibits discrimination in employment against 40-year-olds. Page 539, we have EPA. 2 years of the discriminatory practice unless the alleged violation was willful, in which case the time of filing suit is 3 years. Sanctions, penalties. Up to 2 years or 3 years if the action is willful. Back pay under EPA. Or jury may award double back pay and extend it for 3 years if a willful violation is found. Florida's Equal Pay Statute. The back pay awards are limited to 1 year. Liquidated limitations is 6 months. Coverage. Employed 50 or more employees for each working day during each of 20 or more calendar weeks in preceding or current calendar year. You have 12 weeks of unpaid leave during any 12-month period on the birth, up to 26 weeks unpaid leave during 12-month period for service member family leave. On page 40, we have enforcement. An employee may bring suit in state or federal court. Suits may be not brought later than 2 years after violation unless the violation was willful, or which case the period is extended 3 years. We have Federal Rehabilitation Act of 1973 and enforcement. An aggrieved party must file a complaint of disability discrimination with the OFCCP within 300 days of an alleged discrimination act. 541. Americans with Disability Acts. Employers with 15 or more employees for each working day in each 20 or more calendar weeks in the current or preceding calendar year. We have number 1 here, a physical or mental impairment that substantially limits one or more of the major activities of such individual. So we see a lot of these guys here are acts. You could find these in the index. And also remember to circle the numbers. That's going to help you when looking up some of these answers, which just require you to look up the numbers. Page 542, essential functions of the job. There is no ADA statutory definition. Number 2, job tasks which are fundamental to the job and that an individual must be able to perform in order to get the job done. Number 3, consideration can be given to A, the employer's judgment as to what functions are essential. B, the written job description prepared before advertising or interviewing applicants for the job is evidence of what are essential functions. The ADA defines reasonable accommodations. An employer is not required to offer all possible reasonable accommodations or even the most reasonable accommodations. A, medical examinations inquiries. Pre-employment medical examinations are prohibited with the exception of inquiries of applicant as to the applicant's ability to perform job-related functions. Page 543. Current users of illegal drugs are excluded from the protection of ADA. Page 545. Public Whistleblowers Act. That's another one they ask a lot of questions about. The Act protects covered employees from relation for disclosing their employer's violations of law that may pose a danger to public health, safety, or welfare. We have enforcement. After exhausting all contractual and administrative remedies, an employee may bring suit within 180 days of later of the final administrative determinations or the employer's violation. Page 546, we have 180 days of alleged violation. And up here, 100 million or more. Let's see, 547, garnishment. Make sure you guys tab this page as well, garnishment, because I don't think, this might be in the table of contents, right here. I couldn't find it in the index, but you can find it here in the table of contents. So if you want to tab it and highlight it here, that'll be perfect for you guys, because they will ask you a question about that most likely. The lesser of 25% of weekly disposal earnings or amount by which weekly disposal earnings exceed 30 times the minimum wage. Page 548, record keeping reporting. The Act requires that employees maintain a record of injuries and illness, compile a summary of injuries and illness, and report OSHA accidental involving the death of one or more employees and hospitalization inpatient to a hospital or equivalent medical facility for examination, observation, or treatment of 3 or more employees. So, page 549, we have Florida Clean Indoor Air Act. Penalties, sanctions. An individual who violates the prohibitions against smoking is subject to a non-criminal fine up to $100 for a first offense and $500 for a subsequent offense. Drugs in the workplace, requirements, prohibitions. General, a covered employee must publish and provide employees with a statement notifying employees that the unlawful manufacture, use, distribution, or possession of controlled substance is prohibited in the workplace. Page 551, we have privacy, Employee Polygraph Protection Act of 1988. General, the Employee Polygraph Protection Act covers all employees engaged in affecting commerce. Exemptions. Employees of contractor working on contracts with the Federal Bureau of Investigation and certain employees of security services and employees of entities which manufacture, dispense, or distribute controlled substances. These latter two exemptions contain certain additional limitations, and you have exceptions. An exception to the general rule applies to testing of employees in connection with an ongoing investigation involving economic loss or injury to the employee's business, where the employee had access to the property loss and the employer had a reasonable suspicion that the employee to be tested was involved. 532. We have unemployment benefits. One or more employees. Number one, paid $1,500 in wages during any calendar quarter day for 20 weeks during a year. Exemptions. Employers must file tax reports and pay unemployment taxes quarterly, no later than the end of the month following the end of the quarter. And we have the benefit eligibility 1 through 8. Misconduct. Here's another important one on page 553. Reporting, record keeping. Record keeping is also in the index, so anytime actually a question about record keeping, about whatever subject, you can just look on there, but you will find one of the answers here. Any employer is required to keep for 5 years work records identifying employees, employment periods, hours worked, wages earned, and any special payments, for example, bonuses, gifts made to employees. Penalties, sanctions. A failure to file required reports when due will result in imposition of penalty $25 per report for each 30-day period of fraction thereof in the report later. In the annex, you can also find penalties, guys. Then we have criminal. Any individual or employer knowingly making a false statement or report in connection with administration of the unemployment compensation laws can be filed up to $5,000, fined up to $5,000, and or imprisoned for up to 5 years. We have page 554. The Act also provides for possible criminal conviction carrying fine of no more than $500 or imprisonment for not more than 1 year. Workers' comp. Page 557, we have Immigration Reform Control Act, IRCA. You can find this in the index as well. Under IRCA, an employer must verify the identity of all new employees as well as the individual's eligibility to work in the United States. In this regard, the employer must also complete an employment eligibility verification form, I-9. The I-9 must be completed by employer and employee within 3 business days from the day the employee begins work. 558, record keeping. The I-9 must be kept for all current employees throughout their employment. For terminated employees, the I-9 must be retained by employer for 3 years and the date of hire for 1 year after the date the individual no longer works for the employer, whichever is the later date. So it will ask you about record keeping on this subject, guys, on the I-9. Penalty sanctions, penalties. We have A, first offense, $275 to $2,200 per unauthorized employees. Let's see what else we got here. Looks like we don't have anything else highlighted here, guys, so that'll be it for chapter 5. The next one is, we have one here, labor and employment laws. We have one here on page 275. This is, let's see, what employers need to know about reemployment tax. Who pays for reemployment assistance? You, the employer. Who is liable for reemployment tax? You are liable if you meet in any of the following conditions. You have quarterly payroll of 1,500 or more in calendar year. You have one or more employees for a day or portion of a day during any 20 weeks in the calendar year. Let's see. So this goes all the way over here. Page 278. You have reporting wages. Wages must be reported an employer's quarterly report, RT6. How much do you pay? The tax rate for new employers is 0.0270, 2.7%. 7,000 wages paid to each employee during calendar year is taxable. Any amount over 7,000 for the year in excess wages and is not subject to tax. Excess wages can never be greater than gross wages. Form RT6 and F allows you to report out of state wages paid to employees who worked in another state and are transferred to Florida. Page 279, your tax rate. When a new employer becomes liable for tax, the rate is 2.7%, in effect until the employer has reported 10 quarters. The maximum tax rate allowed by law is 5.4%. The reemployment tax rate notice RT20 is mailed to each employer in December. Then we have Employer's Guide to Reemployment Tax, guys, on page 281. They will ask you questions about this as well. Reemployment tax. On page 282, we have classification of workers, employee or an independent contractor, employer's quarterly report, RT6. Unemployment Tax Act, SUTA. We have current or preceding calendar year. The employer has paid at least $1,500 in wages, which includes for any portion of a day in 20 different weeks within the same calendar year. Page 283. We have if their employment was less than 20 different weeks for the wages paid were less than $1,500 in any quarter. Paid at least $1,000 in wages. And under voluntary coverage by April 30 to terminate coverage for the current year. So this has a lot to do with reemployment tax. Page 284, we have an employing unit is the person, limited liability company, partnership, corporation, or other legal entity for whom service is performed. Then we have employment not covered. Services by a sole proprietor or partner or member of limited liability company classified for federal income tax purposes as either partnership or a sole proprietorship. Let's see. By page 286, Power of Attorney, POA. A completed Florida Power of Attorney form, DR 835, is necessary for an employer's agent or representative to receive confidential information and to act on behalf of the employer about matters concerning the Florida Reemployment Assistance Program. On page 5287, you will get questions about RT6 and RT6 calendar quarter, April 1st to June 30th, due no later than July 31st. So they will ask you a question about this, about when it's due. Page 288, 5288, we have reemployment tax annual report for employers of domestic employees. Only RT7 is due January 1st and later, and late after January 31st. Down below, we have used the employer's quarterly report for out-of-state wages, RT6 and F, to report out-of-state wages. I know these will be hard to find, guys, but as long as you go over 3 times and go over some practice questions, you will start getting familiar where all these terms are in the book. Page 5289, exempt wages. Wages paid to employees of church, convention, or association of churches. Those are exempt from these types of wages. Page 5290, cafeteria plan payments if they are not reportable to the Internal Revenue Service. Employer multi-unit reports. The totals of the multiple work site report must agree with totals reported on the employer's quarterly report. Penalty for failure to file electronically. Per report and $1 for each employee. Is $25 per remittance submission. Page 291. $5 must be paid with the wage data and first installment per payment for the quarter in which the installment election is made. Penalty interest charged for late filing payments. We have charge of $25 for each 30 days or fraction thereof that the report is late. Then we have page 292, correcting your report. New hire reporting. All employers, regardless of size, are required to report all new hires or rehires within 20 days of an employee's hire date. Page 5293, records required and examined. The employer must maintain true and accurate records for a period of 5 calendar years. Page 5294. When an employer first becomes liable for the payment of reemployment taxes, the bargaining tax is 2.7% until the employer has reported for approximately 10 quarters. Successor accounts. Any individual partnership or corporation that becomes an employer by succession has the option of transferring the predecessor's tax rate of taking the initial rate of 2.7%. Page 5297, excess wages. Wages paid in excess of $7,000 per worker per work calendar year. Excess wages are not subject to reemployment tax. That's a key one right there. Make sure you guys highlight the $7,000 per worker. Then we have page 5299, Employer's Guide to Reemployment Assistance Benefits. So anytime they ask you questions about reemployment, you want to come here. And under this, we have monetary qualifications. Page 5300, qualifying for benefits. You have to be able to work, be available for work, be actively seeking work, and registered for work in an employee, Florida. And page 5304, we have tax rate. The percentage used to compute reemployment tax. You have initial tax rate 2.7%, standard tax rate 5.4%, and maximum tax rate 5.4%. And that's pretty much it for this chapter, guys. which is Chapter 5, Labor Laws, or Labor and Employment Laws and Regulations. So thank you guys for watching. Please like, comment, share, and subscribe if you feel this is helpful. And the next chapter we will be going over is Chapter 6, Workers' Comp. Thank you guys for watching.